Hi, I'm Erez, and we are going to be doing DNO and risk. Sorry. We're going to do the DNO risk in the age of cyber, and we have three great panelists for us today. And if you can, looking for Kilaran, Mark, and Scott. So Kilaran McShay, she's from Intact Insurance Specialty. She's a director and in the management liability. Then we have Scott here, Scott Corrales. He's a senior claim at Intact Solutions as well, Insurance Solutions. And then last but not least, we have Mark Moses. Mark is a partner at Clyde & Co. Mark focuses on data privacy and insurance related issues. By the way, who is in the insurance industry over here? Raise your hand. Anyone from the insurance industry? That's it? Okay, anyone from the technology industry? Who hasn't raised his hand? But, oh, do we have attorneys over here? I'm so sorry, oh my God. Okay, attorneys? Anyone who is not an attorney, who is not in a technology company, and he is not in insurance? Anyone? What are you doing?
Marketing.
Marketing. Should we give him a cup just for being here because he's on the marketing?
I think so.
It's here, just because.
Erez, do you mind if I follow up with the insurance folks?
Sure.
Those of you that are from insurance companies, are you on the raise your hands if you're on the claim side.
Good question.
And if you're on the underwriting side, okay, that's not everybody. And if you're not on the claims or underwriting side, could you raise your hand? Okay. And
Broker.
Broker. Okay, fair enough.
Was she the only one?
Did anyone else have your hands up? Yes, sir.
I'm a forensic accountant and works on the business interruption losses.
Fantastic. Thank you. Just knowing where everyone is coming from allows us to cater our presentation to you. And we want to make this interactive, so if any of you have any questions, comments, concerns, disagreements, I love disagreements, bring them up and we can discuss.
We just screen. Right? You can ask. You okay? We good, Mark? Mark, we good?
We're good.
All right. All right, so the topic, of course, is the DNO risk in the age of cyber. And we will first going to go through the DNO and the basics, and we're going to move into the cyber side of the DNO. So, Kilar, who are the DNOs?
So, hi, my name is Kilaran McShay. As we talk about DNO insurance, right, we are going to use that acronym quite frequently. So we're talking about directors, so board of directors of organizations, and officers. So these are people who are hired by the board to run the day-to-day operations of an organization. Directors and officers can be held personally liable for their actions and their capacity to the organization. And so the DNO insurance is intended to provide coverage not only for the DNOs for any personal liability that they might have, but it also helps provide coverage for the company to fund indemnification in instances where that's provided. So again, DNOs held personally liable for their actions. DNO insurance intended to provide coverage not only for claims against the individuals, but in some instances for companies, again, to fund the indemnification for individuals, but there is also some limited coverage for the organization itself or for the actions from DNOs that arise on claims against the entity. Do you want to go ahead and switch slides? So DNO coverage is split up into really three main insuring agreements. This is pretty universal across the insurance industry, although some carriers might refer to it differently. It's structured in three main agreements. Side A is going to be really the main purpose of DNO. It's the sort of core of why we purchase DNO. It's claims against the individuals. It pays on behalf of DNOs, but these are for instances where the organization is not providing indemnification. Either they're not legally liable to provide indemnification or they are not financially able to provide indemnification. This is first dollar coverage. There are some products out in the market where you can just solely purchase side A coverage, but when you're talking about a standard D&O coverage, it's going to include all three of these coverage parts. Side B coverage, so these again claims against the individual, but where the organization is providing indemnification. It pays on behalf of the entity to indemnify, and usually in this instance there is a retention that applies. A and B coverage are the main kind of foundation of D&O, and side C coverage over probably the past decade or so has become broader coverage and certainly a little bit newer because it's providing coverage for the entity itself. It's what we call entity coverage. Actions of D's and O's for claims against the entity pays on behalf of the entity, and usually a retention applies.
Can I ask a question?
Sure.
I'm sorry, were you ready to move on?
We can talk about D&O coverage all the time.
No, but who prepared these slides? Because last I saw them, they were in crayon on the back of the Chili's menu.
I prepared this slide in about 10 minutes right before this panel, so I was told we didn't have a presentation, but I figured it was a good visual. So under D&O coverage, it's considered an all-risk policy. I have a bunch of those, so thank you though. So a D&O policy is considered an all-risk policy. So it's usually providing coverage unless it's explicitly excluded. So a very, very broad wrongful act trigger. This is opposed to a named peril policy. And it's, again, broken up to three policy structures: the main insuring agreements, definitions, exclusions, and administrative. That's things like how the retention applies, where you report, where and when you should report a claim, things like severability and representation. That's in that administrative bucket. But what I think is super important and that people really need to pay attention to when they're looking at their D&O policy is the exclusion section, right? So it should be considered covered unless explicitly stated that it's not. And so when we're talking about cyber breaches and if it's covered under D&O policies, if it's not, if there's any sort of limited coverage, you want to take a look at those exclusionary sections. They're either going to be explicitly excluded, or in some cases there might be some supplementary, sublimited coverage that's afforded under the policy. But the exclusion section is particularly important when you're looking at a D&O policy. So we'll talk a little bit about like common D&O exclusions and some of the supplementary coverage that either could or could not indicate if there's potential for privacy coverage under your policy.
So what I'll say is that the views and opinions of those expressed here during the panel are not necessarily those of their firms or their clients. And with respect to this slide here, or the previous one actually, yeah, the previous one, many of the descriptions there are very favorable towards a finding of broad coverage. I wouldn't necessarily agree with them. However, I wouldn't disagree with them in most respects. There are always going to be two sides of insurance. There's going to be even three sides. There's going to be the insured, there's going to be the broker's view, and then there's going to be the insurance company's view. So while much of what was up there was absolutely correct, others I think are very much part and parcel of the views taken by different parties in the process. And they're all, on some level, legitimate until we get to a court and we test the language, right?
But it's interesting, right? We talk about those exclusions, it's covered unless it's not. When we are thinking about those three insuring agreements, A and B, I said that's sort of the core foundation of why people purchase D&O coverage, because it's for claims against the individual directors and officers, not against the entity itself. But when we look at the policy and the way that it's structured, usually the exclusions apply to the side C insuring agreement no matter what, and there's more limited exclusions when they're referring to A and B. You'll often see carve back for side A coverage. The side C coverage is much more limited in scope, and there are oftentimes very, very strong wording. There is very strong wording related to exclusions for coverage that are solely related to the entity, and a cyber breach is probably a good example of something that you might find an entity-only cyber exclusion, and maybe there's some slight carve-backs for A and B coverage under the policy.
So I can talk a little bit about the exclusions, and the reason we're focusing so much on the exclusions is because if you look at the insuring agreements, they're very broad. They're just going to say the policy covers claims against insureds for wrongful acts. If you look up wrongful acts, it's just going to say any act, error, or omission. And so you're going to read that and think, well, this covers everything. Except what it doesn't cover, which is where you get to the exclusions. So I'll talk about some of the most common exclusions that you're going to run into on a regular basis when you're looking at a D&O policy. These are not all the exclusions, these are just ones that come up a lot in claims. Now I've been doing claims and handling claims for about 7 years. Still feels like every day I'm adjusting. All right. I'm an adjuster. It's called being an adjuster. Come on. Wake up. So the most common exclusions are right up here. You're going to see there's an insured versus insured exclusion. Why do we have that? Because the idea is that your policy is covering you from external threats. It's not covering you from infighting within the board of directors, within the executives. It's not meant to help the company out. Like, it's a little risky when you have executives sitting there at a board meeting saying, we need another $1 million, where can we get it? You'll be the sacrificial lamb, we'll internally sue you, settle with you for $1 million back to the company, problem solved. So we have an insured versus insured exclusion for that. We have a bodily injury and property damage exclusion. That's because you have general liability insurance for those things. And so if you've got a broken leg, if you've got a brick fell on someone's car, that's not going to be covered on your D&O policy, but you probably have another policy that covers it. Then we've got illegal profit and fraud. This comes up all the time. And the important thing to know about this is because D&O policies often deal with financial situations, a lot of times there's going to be some allegation that you've profited in an unlawful way or that you have defrauded someone. And the thing is, this exclusion doesn't apply in a D&O policy until there's a final adjudication and the appeals are exhausted. So what you end up having is a lot of times your insurance company, your D&O carrier is going to defend you, and maybe even the case will get settled. In fact, it often does get settled before that illegal profit and fraud exclusion ever comes into play and before it's ever triggered. Then you've got your contract exclusion. This one is sometimes one of the examples that Lauren talked about, how sometimes individual coverage is broader than the company coverage, even on a private company. This could be an example of that, where you may have contract coverage for individuals, but not for the entity's contracts.
Yeah, it's worth noting that usually contract coverage, if there is any, it's usually defense costs only under the policy, but limited, but still
Yes.
coverage nonetheless.
I'll give an example of that too. And then professional E&O services, these are your professional services. You are a doctor, you are a lawyer, you're an architect, you're an engineer. You have a separate professional liability policy to cover those types of exposures. So sometimes in my enviable job, I have to write a denial letter and tell someone that this particular claim is not covered. And inevitably, I get the question, well, if this isn't covered, then what is covered? And so I want to talk a little bit about some claims that I've dealt with personally that were covered. So a few claims that have come up recently, so you have a taste of what does it look like in a D&O claim space. For private companies, I'm really looking at private companies. So I've dealt with a lawsuit by
And actually, I think we should distinguish that a lot of these, or all of these examples are not referring to public companies. So publicly traded entities have much different D&O policies. From an entity perspective, there will be very limited coverage. It would be securities claims only. So when we're referring to entity coverage, it's strictly referring to any non-public organization.
Right.
That's pretty key.
So for private companies and for nonprofit organizations, which you might be dealing with, you get a lot broader entity coverage than you would ever get on a public company policy. So one example is we were insuring a hospital, and it was selling off medical debt. And so these are people who showed up at the ER, they racked up a big bill, and they may not have insurance to cover it. And so what happens is this debt gets packaged and it gets resold to essentially a collection agency. And in this case, the collection agency turned around and sued for breach of contract, for fraud, for fraudulent inducement, naming not only the hospital, but an executive at the hospital, saying that this debt had been partially settled or discharged when you sold it to me. So you've defrauded me. We stepped in. We are in the process of defending that case. We have paid, the debt itself was about $1 million face value. That was what the hospital bills said. This company paid around $200,000 to buy the debt, so they're taking a steep discount. And so this is the kind of the scale of a claim that we might be dealing with. We're fighting over, we could have collected $1 million, we're never going to collect $1 million, but at the very least you're out $200,000 out of pocket. That's kind of the scale. On another private company in a highly regulated industry, they were investigated for unfair marketing practices, for misleading their customers. In that case, we were defending them in this government investigation. We've paid over $100,000 in the process of defending them, and there's potentially multiples of millions of dollars at stake in civil fines and penalties, so we're involved there. On a nonprofit university, there was a donor who donated a taxidermied collection of animals. It's something that every university should have. And this collection was housed for about 30 years. And eventually the university said, we've got other plans for this wing, and so they got rid of the collection, and they were sued for essentially breach of contract. And this is where a nonprofit policy might be a little broader than a private company policy, because we are defending them on the breach of contract allegation in that particular case. And then we've got a membership model company where they had a forfeiture provision. If you ever stop subscribing, you lose all of your accrued benefits. They were sued for Consumer Protection Act violations, and that was a case where we've worked out a settlement involving vouchers back to these customers, but there was still over $500,000 in plaintiff's fees that got covered under the policy. So there's a lot of benefits to these types of policies. We've got, I'll give one example here, just so you can see the Side A coverage in play. There was a private company that was kind of an upstart during the pandemic, and it unfortunately didn't survive. It took in a bunch of investments, but it just couldn't pivot and couldn't react fast enough during the pandemic. And so the company eventually went under. And the CEO of the company's been sued under state law for securities fraud, for misleading these investors. And there's potentially about $500,000 in investments at stake, and we are defending them under the Side A coverage. So this is where the company doesn't exist anymore. There's no asset there to defend the executives and officers, so that the policy is stepping up to the plate.
So I think those are all really, it's a wide variety of examples of the types of claims that can be reported and covered under a D&O policy. What you didn't hear Scott talk about was a cyber breach, right? And so in general, I think it's the D&O world's philosophy that a D&O policy is a supplement and not a substitute to a cyber or network security privacy policy that's available. You might find on your D&O policy that there's some supplementary payment. So this could be some sort of privacy breach reimbursement, sublimited coverage, very limited in scope. Those supplementary payments and coverages are things that you should also pay attention to in addition to the exclusions. Sometimes they're highlighted because they would have been covered, but they want to provide a little bit more clarification on the policy that this is affirmatively covered under the policy. Perhaps there isn't clarity if a certain type of claim is covered or not, so adding that supplementary coverage part provides the clarity that an insured might need or want when they're looking at their policy to confirm if there's coverage or not. And then perhaps there is kind of this third bucket where it is sublimited because it's an emerging risk. Cyber is a good example of that. And so sublimiting the coverage, because that wrongful act trigger is so broad, sublimiting the coverage does provide a little bit of coverage, but it isn't exposed, then the insurance company isn't exposed to the full limit loss potentially for claims related to those sorts of matters.
Are you saying that insurance policies are sometimes unclear and ambiguous? Well,
no comment.
Because that's really the only way you get in this type of silent, non-affirmative, unintentional cyber coverage into a D&O policy. And I think I agree with you when you're saying that you really do need to look at the policy language, the endorsements, and make sure whether or not there is coverage for a cyber-related event. And if there is, then whether or not it falls within the sublimits or within all of the limits available under the policy. How about situations where a C-suite officer signs off on an attestation to a regulatory agency that they're in compliance with certain cybersecurity rules, right? And there's a regulatory investigation. Is that going to be covered under all policies that cover D&O exposure? I would say no. May it be covered under a policy? Potentially, right? And that's where really knowing what the language says and whether or not there's any way to figure out whether or not that policy is going to respond to that event. Let me give you an example. The New York DFS has been very, very active in enforcing actions against companies that are subject to its regulations. And they're financial institutions, typically. What does financial institutions cover? Pretty much exactly what you think, but it also includes insurers. And by and large, a great many of these investigations are starting to focus in on insurance companies. In this case, it's mortgage insurance and title insurance, in which DFS is investigating active breaches that result from these organizations. And we are talking about allegedly massive breaches, close to 1 billion records of information having been lost in some instances. Right now, these investigations are naming not only the company, but also Ds and Os that were responsible for meeting and attesting the New York DFS regulations. And these individuals might seek coverage under their D&O policy, as well as potentially their cyber policy on the third-party coverage side. I think we talk about first party and third party in a little bit, right? But this just highlights the need to understand whether or not you have coverage under one policy, maybe more than one policy, and whether or not it's limited by the terms of the insurance policies that you're seeking coverage under.
Yeah, so we can go into that a little bit and the distinction between kind of first party and third party insurance. So if we're saying that D&O insurance covers a claim against an insured for a wrongful act, we're saying there's some external threat, someone is making an accusation against an insured that you broke the law. Is a cyber event, and I'm just using, you could use a million different words for it, but a breach, a hack, some sort of cyber event, that event happens, right? You've got a call from your chief technology officer saying, we've been breached. Does that trigger D&O coverage?
Not always. Maybe not at all.
Maybe not at all, because no one's accusing an insured of breaking the law. It's premature, but what can happen is that there's gonna be a fallout after that breach. People are gonna find out, customers are gonna find out, and someone's gonna start pointing the fingers and laying the blame. And I think if there is D&O coverage, it's going to be in that fallout period.
Right, with whether it be reputational harm, financial harm, those are the sorts of things that might make this incident become a D&O claim at some point. But actually, Scott and I were talking this morning, and it was interesting because we have an insured who had an incident, and they reported it to us, and they wanted us to, get on top of this right away. We discovered this breach, and I said, oh, it's so interesting, the difference between cyber insurance policy, a network security privacy policy, and then a D&O policy, and the way that it is handled from a claims perspective. Is that your network security privacy policy, your privacy breach policy, those are usually going to provide some sort of response coverage, right? And so the claims handlers are actually going to be on the front lines and be involved in helping organizations navigate how to deal with the event itself, versus on a D&O claims handling side where an incident might have happened 5 years ago or more, but the claim doesn't actually arise until during the policy period, and then in which case a D&O claims handler would get involved. But it doesn't have the same sort of sense of urgency and that response time coverage or response coverage provided to the insured. So it is a pretty clear and distinct difference between those two sorts of kind of coverages that are available, risk management solutions, if you will.
See, and this just highlights how far we've come, because now we have the brokers who are really saying, D&O is for D&O, and we have standalone cyber for standalone cyber. And that's a good view, okay? That makes sure that you are covered in your claims. And let me tell you how this all came to be and why that was not always the attitude. So in 2011, Sony was hacked, and it involved the PlayStation accounts. 80 million pieces of user data was stolen. Now, I represented AIG in their $50 million layer above two $2 million primary policies issued by other insurers. And Sony sought coverage for that data breach under their commercial general liability policies. Well, your question is probably, well, where's their coverage there? And the other question might be, did they have a cyber tower? They did have a cyber tower. And at the time, cyber towers were not sufficient to cover the types of breaches involving 80 million pieces of information. So Sony went and pursued its CGL carriers, and we successfully defended against coverage under a commercial general liability policy, saying that coverage B, it covers offenses committed by the insured, and that the theft of information and subsequent publication by a third party is not an offense of the insured. And that is the law of the land right now, accepted by many. But does that mean there's no coverage under CGL policies for data breaches? The answer is no. Because if it is an act of the insured that resulted in the publication of that data, courts have found that that is an offense that is covered under the personal and advertising injury coverage section and the violation of the right of privacy. So you see, we have this back and forth now, whether there's coverage, is there no coverage, how much coverage is there? You can see these cases, and I track all of them, and I watch and read all of them. There are some really, really interesting arguments being raised by the policyholder bar that, frankly, courts are buying into. Just look at the recent Target decision out of Minnesota, right? Coverage for loss of credit cards, loss of use of credit cards that had to be replaced as a result of a data breach, okay? There really is nothing wrong with those credit cards, but the court found a sufficient nexus there to say that there was loss of use. Now the interesting thing is the court sort of went back and forth on the issue. We'll see what the appellate court rules. But insurers are tightening up their language. And following this Sony PlayStation litigation, we had ISO come out with their forms, essentially adding by endorsement exclusions for electronic data and privacy-related issues. Now the discussion is being driven by reinsurers, who are really reining in their silent cyber exposure. So the reinsurers are putting on their treaties reinsurance exclusions, excluding coverage for cyber-related events under non-standalone cyber policies. Well, guess what? The insurers are now analyzing that and saying, well, I'm now exposed, so I'm going to tighten up coverage. So what we're going to see in the marketplace is, if you're not depending on your standalone cyber policy for your protection for a cyber-related event, you could find yourself out of luck because there's going to be a tightening in the market with respect to silent cyber.
Right. You could run a search for the word cyber. You know, you might find that there's a cyber exclusion that specifically addresses cyber. You might find that there's a sublimit for cyber expenses, or you may find that it's silent. It doesn't really talk about cyber.
Yeah, it might say computer.
You could say computer. You might want to
say
say
data.
Could say privacy.
You could run a couple different
Network.
queries, but the point is that things are in flux right now, and that there is no one standard form that's being used by every D&O carrier.
Question?
I would just add, from a cyber coverage perspective, it's so important that you understand the cyber policy as well. Every cyber policy should and does have an EPL exclusion, an ERISA exclusion, a breach of contract exclusion, a securities exclusion. But if those exclusions don't have carve-backs for losses, and a lot of these like off-the-shelf policies are really, really weak in that area, if they don't have carve-backs for a network security failure event or a data privacy event, then you should have had coverage for a resulting securities class action that maybe is not covered under the D&O, or an invasion of privacy claim that wasn't covered under the GL because it should have been covered under the cyber policy, right? So you're right, the other insurers are compartmentalizing, and that's going to happen, there's nothing you can do about it, but like you need to make sure then that your cyber policy dovetails, because all those exclusions will come to market as well.
Yeah, so the comment was, know your cyber policy and the exclusions, because you may find yourself out of coverage or there being coverage gaps within that policy, and to make sure that your program blends and covers you from all bases. Did I reiterate that accurately? Okay, thank you, because some people on the video can't hear people when they speak in the audience, so I'm just repeating it for the benefit of those that might watch this later, because that was an excellent comment. Thank you.
If I'm plaintiff's bar, first place I go is the board minutes. You show me where you discussed safeguarding customer data. If you're not documenting that in board minutes, I'm going to probably craft a complaint of failing to secure customer information, failing to secure a fiduciary manner, and so forth and so on. If you ask yourself, I can see a public company. Private company, where is it going to come from? Banks. because every company's got a banking relationship. And when that banker whose assets are, or whose loan is secured by the assets of the company are depleted because of a security breach, I'm going after the director and officer from the banker's standpoint for remuneration and reimbursement, and that's going to come from the D&O policy potentially.
Right, so the comment here was, with respect to the plaintiff's bar, they're going to look directly at the board minutes to find out what kind of due diligence and monitoring and supervision they're doing over their obligations to control and secure data within their organization. And if that isn't present, that's going to form the basis of the allegations in a subsequent lawsuit if there are damages to the corporation, and they're going to look to the D&O policy to cover those losses and reimburse the corporation, right? Thank you.
Right, and I think that when you're looking at management and what do they consider their reasonable duties to the company, technology, data security, that's becoming more of a day-to-day concern. I mean, we have chief technology officers that we didn't have, 20, 30 years ago. So it's starting to become more generally recognized that data security is part of the executive's role.
Anyone else have any comments, questions? The dialogue is really great, so I appreciate those that are joining the conversation. Anybody else?
What
Be
about
brave.
private investors?
It's Friday. Nobody's judging you here.
Private investors.
Private investors, sure.
Private investors can be also suing the DNOs.
Right, just because you're a private company, you've got investors too, sure.
Right? So you guys are very depressing. Seriously.
I think what we're trying to say is there's no clear answer, right? The answer is maybe. There might be coverage under a D&O policy. There might be coverage under a network security privacy policy. It depends on the policy language. And if you're unsure, the best thing to do is if an incident happens to have an organization report that incident to all of their insurance carriers. Because there might be supplementary coverages under D&O, there might be full limit coverage, you might have a network security privacy policy that denies the claim, but you never know, and providing notice to all of your carriers and making sure that you do it in a timely manner is really the only way that you're going to really maximize the coverage available that you purchased.
Right, like Mark, you have a cyber breach, who do you report to?
Ghostbusters.
Which carrier do you report? Who do you call? Who are you going to call?
Ghostbusters.
Well, that's a great point, and I think it was touched upon actually during the last panel, and every member of the panel had a different response. The lawyers wanted you to contact them first, the insurance company wanted you to contact them first, and then the computer forensics company wanted the first call.
I'm an underwriter, I didn't want anybody to contact me.
So who does the first call go to? Well, whomever it's going to be of that group, could even be the broker.
Even?
Yeah, sure.
They're calling us all the time.
Here you go. Point proven. So
We're on the speed dial.
you see, and that's service. So intouch insurance services, meeting your insurance needs. So you're going to do whatever your manual and your incident response plan says to do, okay? And not all of them are the same. You don't contact the same people, and for goodness sake, all important individuals on that response team should have a hard copy of your incident response plan. There's no sense in putting it in a computer system that could be frozen and not inaccessible because of a ransomware event or some other malware event.
That would be funny, right?
Not so much.
In ransom, I'm not going to release with your response team.
Can I pay some of the ransom so that I can have my response plan back?
Yeah. Right. So I got a problem here with you guys, Like, so how do you read a policy? What do you do? Like, there's exclusions, there is the no's, claims, very depressing. How do you read a policy?
I mean, I typically go straight to the exclusions because in almost every case, it's very easy to determine there is someone making a claim against an insured for a wrongful act. And so it's straight to the exclusions for me. It is, is there anything in here that looks like it applies? And then you can get into different issues of timing. Does this fall within the policy period? Was it too late to report it? Some of those peripheral issues. But to me, because the coverage is largely defined by the exclusions, that's where I go to figure it out.
So we're starting from the last page to the front. You want to say more?
I start with a factual narrative. I wouldn't even touch the policy until I have the facts at hand in order to evaluate what gave rise to the event, what caused the event, who was involved, and I want to identify the parties that were affected. Why is that? Because I'm going to go very methodically through the policy. I'm going to start with the declarations page. Well, what entity was affected? Okay, it's not the named insured. All right then, what's the definition of insured? All right, it's not the definition of insured, it might be in subsidiary. Okay, it's subsidiary, but they just acquired it. Okay, they just acquired it, but it's only 5%. Right, does this trigger coverage for the entity that's asking for coverage? Very basic, and a lot of people just go right past that because they look at a familiar name and they don't see that many companies these days have various levels of affiliates. And you'd be surprised how many times you get, insurers will get noticed and there will be pushback saying, please let us know how this entity is related to either the named insured or qualifies as an insured under the policy. And then they come back and they withdraw the notice because that entity had its own cyber policy. And it's not covered under a holding company or a parent. So I start with the declarations. And then I go to the insuring agreement because that's a threshold issue. If it doesn't fit in the insuring agreement, I don't need to look at anything else. Case closed, doesn't fit in the insuring agreement. The insured has the burden of proving that it fits within the insuring agreement. So the insurance company will go back and say, you've given us facts, and we appreciate it, and we want to help you with this, but we're having difficulty finding coverage within the insuring agreement of the policy. Can you please provide additional information or establish why this would be covered under, and then you rattle off the insuring agreement. Maybe you think it doesn't qualify as a wrongful act. Maybe you think it doesn't qualify as a claim. Maybe it's the insured issue. But that's a threshold issue, and if it's not met by the insured, there's no coverage. Then I might get to the exclusions, and I might say, by the way, even if you get past the insuring agreement, you've got to contend with exclusions A, C, D, F, G, H, I, as well as endorsements 1, 5, 7, 9, 10, 21, 31, so on and so forth. And what does that do? It manages expectations. Because nobody wants to just ask about the insuring agreement and then say, well, what about insuring agreement A? And then they give you an answer to that. What about C? I mean, that's how you get a frustrated insured, a broker that is now in a situation where they're compromised with their client who they thought had purchased insurance. And that's when I think insureds start saying, well, I might need some legal counsel of my own. And then that's really going to prolong the process when it should be a mutual exchange of information. The facts either support coverage or they don't.
The first thing I do is I usually give it to Scott and say, hey Scott, is this a notice of a claim or is this a notice of a circumstance? Is this covered under the policy, yes or no? So I usually start with the definition of claim. You can report notices of circumstance under a D&O policy, but if it doesn't meet the definition of claim, a capital C claim, within the policy form, we treat it a little bit differently on the claims handling side. But again, the difference between D&O and a true cyber policy is that we're not intended to provide that response coverage in the same way a cyber policy would. That's really where you're going to want to work with a cyber insurer to help with that piece of it.
And that's a really important point, especially when we're talking about the intersection with cyber, which is that you don't necessarily have to have a claim yet to report something under your D&O policy. You can report circumstances that could give rise to a claim. So what you do is you say, we had this cyber breach, this is what happened, and we think these are the people who may sue us down the road for failing as executives of the company, for managing the company properly, or for failing to safeguard.
Can you tell them what the definition of claim is on standard D&O policy? Because that's different than the cyber policy, I think.
So,
For clarity of people.
a claimant is really anyone who's
No,
bringing...
claim.
Oh, a claim.
Written money for...
Yeah, so that can change too. So typically a claim is some sort of a legal proceeding. So it can be an EEOC charge, it can be a lawsuit. A lot of policies also include some form of written demand Sometimes it's a demand for only monetary relief, sometimes it can be a demand for monetary or non-monetary relief, and those are kind of the two biggest categories that I see. There might be some investigation coverage, but you'd have to look really closely at that. But you can give notice of this cyber event. You probably should give notice of this cyber event, because what can happen is you switch carriers. Next year you go with a different carrier, and then you suddenly have a D&O claim or some other sort of claim pop up on this new relationship with this new carrier based on a cyber breach that happened with the old carrier. And the new carrier is probably going to say, we're not going to cover that because you knew all about that when you first started this relationship with us and we first started insuring you. And so what you want to do is essentially lock in the timing of your claim, and the way you do that is you give notice. You give notice of circumstances that could give rise to a future claim.
So best practice would be to put everyone on circumstance.
Tender to everyone, just like
Tender your
GL,
claim,
the
tender the
cyber,
incident to everybody.
The DNO, the all.
That's just exhausting.
What?
It's exhausting from the insurer's standpoint, especially where you get individuals who were sued in their capacity as a D&O and they have to notify their umbrella carrier at home. I get it. You know, you have to cover your bases. So the advice is not unreasonable, but you know, you never know in this day and age, given the case law that's coming out. Sometimes they sneak one past the goalposts.
That's a great point, but so you have a ransomware attack. Bad guys say they exfiltrated or copied data. They're going to release it in the dark web unless you pay. You pay it, time goes on, 3 years goes on. Bad guys put it in the dark web 3 years from now. You get a class action suit. You have a late notice reporting issue because you didn't notify the D&O at the time, even though there was no claim or written demand.
So maybe summarize the claim. So bad guys come in, exfiltrate data, take the data, say they're going to publish it on the dark web. Company pays to suppress the publication. 3 years goes by, and that data finds its way to the dark web, and litigation ensues. And the question is whether or not there's coverage for it.
Without prior D&O notice.
Without prior D&O notice.
So the notice is usually to give notice of a claim. So I don't know that it's going to be a late notice issue, but it could be is a prior knowledge issue.
Right.
And that comes up with when you have a fresh new relationship with a new insurance carrier. They only want to cover the stuff that you didn't already know about when you first started insuring with that new carrier.
But what if it's existing too? You have a prior knowledge issue.
It's not quite the same. If you have continuous coverage with the same carrier, it's a little different.
Yeah.
The risk tends to come up when you switch carriers.
Yeah, only typically on a policy where there's an explicit exclusion that says it's a prior X exclusion, where there would be a date that is identified as a date in the past where anything prior to that date wouldn't be covered, anything going forward would be. And usually if you keep coverage with the same carrier, they continue to provide coverage continuity every year.
How often does the other insurance clause come up? You know, if there's coverage on both sides, is it placement of excess over the cyber coverage? You know, are you splitting costs at that point in time, or?
I would ask my coverage lawyer.
Depends who I'm representing. But other insurance provisions will normally cancel out if they're both saying that they're excess. They'll be found to be mutually repugnant, in which case both carriers will have to work out some sort of cost-sharing allocation of coverage. It's a thorny issue because what may be covered under one policy may not be covered under the other. There are percentages, there's a weighting based on claims, there could be a weighting based on potential damages arising from the claims that might, even though there might be more claims falling on under the D&O, the real damages might be under the cyber policy. There are a whole host of issues, but it will come down to a comparison of the other insurance language, and that frequently does happen, which is why in all of the coverage letters that at least go out from my desk, the information concerning other insurance policies that have been given notice, for which they have responded, or that might otherwise be available to potentially cover an event, have to be provided by the insurance company. But I want to go back to the example because I thought it was a good one. For purposes of discussion of coverage issues, but I want to talk about a little bit about attribution. Even 3 years goes by and personal information finds its way on the dark web. unless there is a simultaneous publication of the communications between that bad actor and the company and tying it into the database that was stolen from that company, attribution is going to be a very big problem. And why do I bring up attribution? I bring up attribution because of two cases that are currently making their way through the courts involving NotPetya, which was an attack in 2017 by Russia on Ukraine, which arose out of the use of tax software. So Russia wanted to attack Ukraine, and they thought the best way to do that was to unleash a malware virus into tax software used by a lot of Ukrainian businesses. But those businesses had sometimes global operations, like Merck and UPS, FedEx, and other companies. And that malware just propagated and went worldwide, causing collateral damage outside of Ukraine, resulting in $10 billion in damages, right? I mean, when you look at Merck, it had, I believe, coverage for $1.75 billion and damages of $1.4 billion. The numbers might be a little off, but it's around $1 billion. And the question there, of course, is whether or not the war risk exclusion applies to preclude coverage, and whether or not the insurers could attribute the acts that resulted in NotPetya to Russia such that it was state-sponsored and that it was, in fact, covered under the war risk exclusion. Now, without getting into those decisions, attribution on future events, I think, is going to be part of the analysis of any kind of lawsuit resulting from the publication of information from a prior breach. And there are going to be a number of defenses that insureds can use in a situation like that, because our information, how many people have been part of a data breach where you've gotten a notification to get free credit monitoring? Everybody, I hope? Yeah? No? Maybe not? Your information is out there. There's no doubt about it. So how do you say that you've suffered harm as a result of one breach today as a result of a breach 3 or 4 years ago? But that's just an issue I have with respect to damages from the loss of data at this point. I don't think that the costs that are being settled at for these types of cases really merit what they are settling at. I think they should be much lower, in my opinion. And I think that's because the resulting harm, I think that the courts are getting it right. Every year we get new cases that say, the harm, what's the result of the imminent harm? Or is there a real reasonable risk of harm? And we're just not seeing that come to fruition.
I guess back to the other insurance clause comment too, and certainly when we're talking about $1 billion in damages, it doesn't really matter at that point because usually everybody's paying under their policy, but under a D&O policy it does come up quite a bit, and that's because, again, we go back to that wrongful act trigger. It's the all risk, it's a super broad wrongful act trigger, as opposed to like an employment practice liability policy where that other insurance clause will typically say that it is affirmatively primary. And that's because that's a named peril policy. When you look at the wrongful act coverages, it's very clear, right? It's a wrongful employment decision, wrongful termination, sexual harassment. And so you know exactly what's covered under an employment practice liability policy versus a director's and officer's liability, which Scott had mentioned. When you read the definition of wrongful act, it says any error, omission, misstatement. So a lot of things could fall under that sort of description. And again, broad wrongful act trigger versus a named peril policy. The other insurance clause is particularly important because there are standalone policies or coverages available that a D&O policy is not intended to cover, like cyber, like pollution, and any sort of environmental claims. That's why you see those explicit exclusions on the policy, because they're not intended to cover those types of matters. There are separate policies available that specifically cover those very unique situations.
We need both policies.
Yeah, I imagine, right? It's a supplement, it's not a substitute.
Right. Buy all the policies.
The market is getting...
Pushing insurance.
What would you expect me to say?
Yeah.
Work for an insurance company.
That's right, yes.
One quick question. Do you think we're living in a post-Side A world? Like when I was doing private company D&O, everything but murder was covered under Side A. Is that you think going to change, or can D's and O's still trust that to be their
He said murder.
personalized?
Everything but murder, yeah.
It might be covered.
You never know.
Yeah, so I absolutely believe in Side A coverage. I think it is the foundation of D&O coverage. It is for claims against individuals when the organization is not indemnifying. That was the purpose of D&O being created. It's first dollar coverage. If we can't rely on Side A coverage going forward, then I don't know what the future holds for D&O insurers. So for that reason, I'm a big advocate for Side A coverage.
Yeah, I think sometimes people talk about D&O insurance as sleep at night insurance because these executives want a policy there when everything else fails, right? When the company fails, and I've seen those claims. The company goes under and there's no money to back you. And so you've got that Side A coverage, that sleep at night insurance. Or another way to look at it is maybe you buy a cyber policy for your company to insure your company, but you're buying a D&O policy for yourself.
You see what I have to work
That's a
with?
great point.
You see, I'm just telling them, you see what I have to work with.
It sounds like you have a lot of options.
I'm okay, I'm fine.
You have a lot of options. It's just an a la carte menu. You can pick a little of A, a little of B, and you're not going to get it all in one shot. But I think we're getting signaled that we have less than 5 minutes. So if any of you have questions and comments, ask them now while we're up here. Like I said, it's Friday. Go ahead, take a shot. And anything you can ask, anything you wanted to ask, please, cyber or D&O related. No? Okay, I think yeah, go ahead.
Yeah,
I've heard that some insureds store all of their policies on their systems, which provides a unique roadmap for any type of threat actor accessing their systems. Obviously, especially with a ransomware incident, they're going to make a demand for the insurance amount. Do you recommend they store those on paper somewhere else and not in their system?
Oh my goodness, you're my favorite. You're my favorite. This issue is near and dear to my heart because I always thought that if threat actors really wanted to follow the money, they would go after brokers' computer systems or insurance email computer systems, not really the insureds, but get the deck pages for all of these named insureds and find out the limits. And then one by one, just go down the road and say, you've got 10 million in coverage, we'll take 5. You've got 5 million coverage, we'll take 1. So I have always been an advocate, which is the voice in the forest, of placing policies on a blockchain that are fully secured and accessible only by the broker and the insured through a secure portal maintained by the insurer. So that provides availability for the policy. It provides information related to the policy. You couldn't even print out this policy in my world. It would just be there and that would be it. And you would have access. You would always know where it is and you would always be able to check it. And so would your broker. But who wouldn't be able to get it? It would be a third party. And you're saying, well, what if the insurance company gets hacked? We have a lot of companies here that do cybersecurity. I'm sure one of them would be very happy to secure this. Plus, if you use appropriate encryption, if you use appropriate safeguards in terms of logging into the portal, you would be able to prevent bad actors from getting into that roadmap that would basically fund them for the next year until renewals.
Where's a VC firm? Let's get.
Yeah. I mean, I guess. So who would pay for that, right? I guess it could result in a if this became a problem, which we haven't really seen, but if this became a problem, it would result in better loss ratios because you're not paying out for those claims that otherwise would have happened if people had access to those debt pages. So great point, at least from my perspective.
Yeah, certainly plaintiffs' lawyers know that playbook, right? They want the policy first thing because they are going to gauge their demands based off of what's available.
but that's fine, a good insurance broker. So, thank you.
Awesome. Well, thank you guys so much. There
Thank you.
are some freebies up here. If you guys want to grab any, please feel free. But it was so nice to present in front of you guys today, and hope to speak to you guys after this panel.
Thank you guys, great education. What is Directors and Officers Insurance? Does anybody know?
It's not side price.
Going twice?
How many sides?
True. Don't worry about it, read it later, but buy the coverage. Anyways, make sure you buy. We have a quick break and then we have a quick turnaround at 3:15. Again, if you are going to the reception of the game and do not have a wristband, please go downstairs to the